Hello and welcome to this month's edition of The Legal Scoop, our webinar series here at LOMAD, where we discuss recent decisions from the Court of Appeals or the Third Department. My name is Brendan Shannon. I'm an associate attorney here with LOMAD, and today I want to talk about a recent decision from the Third Department on November 13th, which is the Crine v. Greenhaven Correctional Facility case. And what's interesting about this case is it's an SLU case involving Ginduso, and for those of you who aren't familiar with Ginduso, I imagine many of you are. Ginduso is the decision that allows us to basically take an offset for a prior SLU to the same member that there's an SLU for in a newer claim based on a prior SLU. So stating that again, if a claimant has, say, a 15% SLU of the right arm / shoulder from a 2010 case, and now in our 2023 case, the claimant has 30% SLU for the right arm / shoulder. Typically under Ginduso, what you were always able to do is you could then offset that prior SLU against the newer one to have a lower SLU payout. Subsequently, the Court of Appeals came down in the Johnson decision, which is Johnson v. City of New York, and the citation for that is 38 NY 3rd 431 from 2022, and sort of vaguely provided that if the claimant provides some sort of evidence that essentially the second injury, considered alone and not in conjunction with the initial injury, caused an increase in the claimant's SLU, and this could include medical evidence that a prior injury and the second injury are separate pathologies that each cause different individual losses of use of the subject member, say the right arm, then Ginduso might not apply. Now, the key there is that the claimant does bear some sort of burden of proof to either get that evidence into the record through their own doctor's opinion or through perhaps cross-examination of the IME. Now, in this case, the Third Department took issue with the board's decision because the board sort of automatically applied the Ginduso credit. So I mentioned it as an offset. That's sort of what it's considered. It's considered a credit. Automatically applied it despite the fact that the claimant did produce some evidence from his own doctor through testimony regarding the degree to which the 2020 knee injury increased, so the newer injury increased the claimant's loss of use beyond his prior knee injury. So this is an interesting case because it's basically just reaffirming and reminding all of us of the Johnson decision, which is that, again, don't assume because there's a prior SLU to the same site that you're automatically going to get a Ginduso credit. If the doctor uses what we like to refer to here as those magic words, as far as the degree to which the new SLU is different, materially different from the prior, then there has to be litigation on that in and of itself to determine whether Ginduso applies. So if the claimant doesn't produce any such evidence, then the likelihood of Ginduso applying, you being able to take credit for a prior SLU, is pretty high. But it's just something to be aware of when you're looking at your cases and you're considering whether you want to have an SLU opinion looked at or not by defense counsel. If there is a prior one, it's almost always a good idea to have defense counsel look at it and to determine whether there's any issues as far as whether Johnson will apply or not, and whether you're going to have any issues getting a Ginduso credit. So very interesting decision, and we'll be back next month to discuss more interesting decisions. If you like this video or any of our other video series here at LOMAD, please subscribe below, and I will see you next month.